what we're doing now. We explain people's rights and make sure that people are aware of the sorts of things that are protected under California employment law, including rights to, discrimination, whistleblower protection, privacy, things like that that people have in the workplace. So the way this presentation is structured is it gives you a little bit of detail about the wage and hour rules in terms of, how much people are supposed to be paid and under what circumstances they're supposed to receive more money or less money. And then after we go through some of the wage and hour stuff, we'll just touch on a few of the other rights that you guys have in the workplace. And what I would encourage you to do, if questions occur to you while we're going through some of this stuff, maybe from circumstances that you've had in some job that you've worked, or circumstances that somebody else might have had, feel free to ask questions about that at the end, or maybe we'll have a pause at some point for some questions if people are burning to ask. But yeah, so the idea is to get a sense. There's no way that anybody's going to be able to memorize all this stuff. Even I don't have this memorized, and I do this for a living. And so, but you do want to get a sense of what the law does protect so that you have some idea of what to look out for. And then if you see something that looks questionable in the future, you can call legal aid, and we can take a look at the circumstances and give you some advice as to whether there's a violation or not. And if there is a violation, then we can help you figure out how to address that violation using the legal tools that are available. Okay, so without further ado, let's start talking about some of the concepts in the wage and hour law, and then we'll see what we pick up along the way. Okay, so if you'd like to advance to the first slide, let's go. All right, so here we go. So this is the most basic concept that underlies the California wage and hour law, is that everybody has the right to receive at least the California minimum wage. The California minimum wage is currently $15.50 per hour. There's also a federal minimum wage and a local minimum wage. And among those three, whichever one is the highest is what your employer has to pay you, okay? So in California, the law says that the wage is currently $15.50 per hour. So if you know anybody who's getting paid less than $15.50 per hour in California, then there's a legal violation going on. The minimum wage is indexed to inflation. So every year they calculate how much inflation has taken place, and then they generally will raise it on January 1st. And so on January 1st of next year, the California minimum wage is going to be $16 an hour. Okay, so anybody earning less than $16 an hour is going to be required to get a raise on January 1st. Okay. As I said, the federal minimum wage also applies, but because it's only $7.25 and hasn't been raised for years, it's kind of irrelevant in California because we're supposed to pay more. Okay, for workers who are under the local minimum wage, it's even higher. So for example, in the city of Los Angeles, the local minimum wage is $16.78. And then there are lots of other cities in California that have a higher local wage. And then some of the local communities have passed even higher wages for certain kinds of workers that they think need extra pay. So for example, in Los Angeles, there's a higher wage that's required for workers at the airport. There's a higher wage for hotel workers in some cities. And so it's not as simple as just knowing the minimum wage, but I definitely promise you, if anybody's getting less than $15.50 anywhere in California, that's against the law. Okay. And then what it says at the bottom is promised wage. Promised wage is a reference to the fact that when you make an agreement with an employer to go work for them, and they make an agreement to pay you to work for them, That is a legally binding contract, okay? And so that means that if the employer promises you a higher wage, such as $25 per hour, they're still breaking the law if they pay you less than what they promised. They have to pay you what they promised, and they can't defend themselves by saying, "Well, at least I'm paying the minimum wage." If the employer has promised a higher wage, then you have the legal right to recover that promised wage in some kind of legal action because the law requires the employer to do what the employer promised, and in this case, that would be to pay a higher wage. Okay. Hopefully that makes sense. Let's talk about some extra circumstances that affect the minimum wage on the next slide. All right, so here are some extra considerations, okay? In California, the law says that you must get paid the minimum wage even if you work by the piece or get tips, okay? So what does that mean, working by the piece? There are some jobs where they say, you know, we're not going to pay you by the hour, we're going to pay you by the piece. Sometimes that means we're going to pay you, for example, for every shirt that you sew, or every manicure that you do, or every car engine that you change the oil on, and we're going to give you a certain amount by the piece. That's perfectly legal. You can have a piece rate, but the amount that you're earning from the piece rate has to be at least what it would have been from the minimum wage for the number of hours you're working. And so if it turns out that your piece rate is giving you less money than you would have gotten at the minimum wage, then there's a problem. Okay, so if you work a 5-hour shift and you're getting paid by the piece and you're wage, and so that's illegal. Okay, another concept is the tip. The United States, it's perfectly legal to pay somebody less than minimum wage if they're getting tips, because the most of the states say, well, you know, their tips will make them up to the minimum wage. But that's not true in California. In California, even if you're getting tips, they still have to pay you at least the minimum wage. Okay. So, you know, waiters in fancy restaurants who are getting hundreds of dollars in tips, they still have to be paid at least $15.50 per hour. You know, people who work in other tipped industries like hairstylists and manicurists, all of them have to be paid at least the minimum wage, and then they get to keep their tips on top of the minimum wage. So by definition, anybody in these tipped industries should be making a lot more than minimum wage because they get to keep their tips on top of minimum wage. And if anybody's not getting minimum wage in a tipped industry, then that's illegal, and we do see that sometimes. Okay, so remember that right that you have in California. Okay. And then down below, it's talking about people who are paid on the piece rate. So you're supposed to, in order to figure out if you're getting paid properly, it's a little complicated. You have to take the number of hours you worked and then divide that by, you know, divide the amount that you earned from your piece rate by the number of hours you worked. And you have to see if it's still the minimum wage. And it becomes complicated sometimes because sometimes the employer says, well, you know, you have these hours to work, but then you also have to be sitting in the shop waiting during this time, and then maybe we have a meeting and you have to sit through the meeting. But you have to take account of all the time that you're under the employer's control and make sure that all of that is being paid. And if there's a problem in terms of the amount of pay, then that's something that you can take legal action to take care of. And then at the bottom, it's reminding us that the courts have decided that piece rate employees still get paid breaks and overtime. Okay, so that's even more complicated to try to figure out how it works. But they have to give you extra pay to cover your breaks, even though you're getting paid by the piece. And then they also have to do extra calculations to make sure that you're getting paid overtime, even if you're getting paid by the piece. So all of these rules that we're going to be looking at apply to people, whether they're getting paid by the hour, by the piece, whether they're earning tips. I mean, all of these people are covered, and it's important that you remember that you have these rights And if you have questions or have a circumstance, then we can look at it and make sure that the scheme that your employer has put together is legal. Because a lot of the time, the employers just open up a business and then they just make up their own rules for how they're going to pay you. And sometimes they follow the law, and sometimes they make up something and they think it's okay. And until somebody sues them, it's not like the police are going to show up and say, hey, you're not paying properly. um Somebody has to take a look at this and say this is wrong, and then that's how these kinds of laws get enforced. All right, so that's why it's important to remember your rights and to check if you have any kind of questions. All right, so having talked about minimum wage, let's go to the next slide. All right. So this is an important point, and unfortunately, it's stated here in a kind of a legalistic way. It says that an employee may not waive the minimum wage requirements. Such a contract is illegal and unenforceable. Okay, so that means what this means is that, I mean, most employers would prefer to pay as little as possible. Okay, they would prefer not to pay the minimum wage. And there are some workers who would really like to have a job, or, have some particular reason why they want a particular job. And they say, hey, I'm willing to work for less than minimum wage. And of course, the employer is willing to pay less than the minimum wage. So the question is, can I agree that I'm going to work for $10 an hour if both I and the employer want to do it? And the answer is no. That kind of a contract is illegal, even if everybody is okay with it at the time. And so what that means is that the employee, even if the employee promised to take $10 and said they were fine with $10 and signed 15 papers and like swore on a stack of Bibles that they really wanted $10, it's still illegal. Okay. So the employee can turn around tomorrow, sue the employer for the unpaid minimum wage. And the fact that the employee agreed to take less doesn't matter. Okay. It's not enforceable. The courts are not going to give effect to an illegal contract to pay less than minimum wage. Okay. So this comes up sometimes when you see circumstances where somebody allows somebody to work in their shop or something to get some extra experience, and the person agrees to take less than minimum wage, or sometimes to work for free. I mean, we had a bunch of cases years ago where a lot of big businesses were letting in interns who were recent college graduates who were helping out around the business and supposedly getting experience. And the intern said that they didn't need to be paid, and of course the business doesn't want to pay them. But all the interns sued the businesses, and all of the businesses had to pay minimum wage plus a whole bunch of extra damages, because the law says that you have to pay minimum wage. You can't waive around it. Okay. There are some exceptions. I mean, obviously, if you have a charity or a church and you meet some special rules, then it is possible to volunteer to work for free. So I mean, if you do stuff at your church, that's not illegal. But if it's a private business, they're going to have to pay the minimum wage. Okay, let's move on. All right. So having talked a little bit about minimum wage, let's talk a little bit about overtime. Okay. I'm sure most of you are familiar with this concept, but let's look at the specific rules in the state of California. Okay. So you have to get an overtime rate. An overtime rate means at least 1.5 times your normal hourly rate anytime you work over 8 hours in a day, or anytime you work over 40 hours in a week, or anytime you work 7 straight days. Okay, any one of those 3 things creates the requirement to pay overtime. So even if you only work 10 hours in the whole week, if you do all 10 on the same day, you've got 2 hours of overtime because you met the first criterion and you worked more than 8 hours in a day. Okay. Anytime you work more than 40 hours in a week, even if you're only working a few hours a day, if it adds up to more than 40 over the course of the week, every single hour after the 40th hour is overtime. Okay. And anytime you've worked 7 consecutive days with no day off, okay, even if it's just a few hours a day, on the 7th day, your first 8 hours of work on the seventh day are going to be counted as overtime. Okay, and the reason these rules exist is to encourage employers to make the workers work fewer hours because they have to pay overtime rates under all three of these circumstances. Okay, employers usually even dubious employers will pay after 40 hours, but sometimes they miss the fact that they're required to pay after 8 hours, even if it's less than 40 hours in the week. And it's very frequent to see people not getting paid extra overtime on the seventh day. But all three of these are required by law. And if any of these kinds of violations is taking place in a workplace that you're aware of, there's probably liability, and the employer probably owes you some extra wages. All right. There's some more overtime rules. Let's go to the next slide. All right, so this is double time. Okay, we just talked about overtime, which is 1.5 times your normal wage. There's also double time. Okay, if you work a really long shift or a really long work week, you're probably going to be owed some double time wages. Double time means twice your normal hourly rate. So if your normal hourly rate is $15.50, for double time hours, they need to pay you $31 an hour. Okay, you have to be paid double time anytime you work more than 12 hours in a day. Okay, so that means that if you work 13 hours in a day, the first 8-hour period is your regular rate. The next 4 hours from 8 to 12 is going to be overtime rate, 1.5 times your normal rate. And then the last hour, the 13th hour, is double time. So you have to be paid double. Okay, and just like the other overtime, you also are entitled to double time on the 7th consecutive day. So if you work every single day of the week, no time off, on the 7th day, you're going to get your first 8 hours paid at overtime rate, 1.5. And then anything after 8 hours on the 7th day has to be paid at double time. Okay. These rules get overlooked all the time, especially by, mom and pop type places. They might not even be trying to steal your money, but they are because they're not following the law. So you have to make sure that you're getting your double time. If the employer is using a payroll processing company, they'll usually calculate it correctly. But if the employer is just doing it themselves, you've got to watch out and see if they're following the law or not. Because if they're not, they're probably going to owe you some money and some additional penalties. All right, let's go to the next slide. All right, so this is talking about sick time and vacation time. So these are two different concepts. Sick time is required by law in California and some of the localities of California. Okay, so that means the employer has to give you paid sick leave. They have to allow you to use at least 24 hours of paid sick leave per year. Okay, so that's supposed to be 3 days that you can take off if you're sick and you can't come into work, and the employer has to pay you. Okay, as of January 1st of next year, they're changing the law, and it's going to be 5 days a year or 40 hours that the employer has to pay you. This is required by law. All the employers have to do this. You have to give the employer a reasonable notice when you're sick and you're not going to be able to come in. And then the employer has to allow you to use currently 30 hours. Next year, it's going to be 40 hours. Okay, so that's how sick time works. Okay, everything else beyond sick time is not required by law. Okay, so the employer does not have to pay you for holidays. Okay, the employer does not have to give you paid vacation. And the employer doesn't have to give you extra pay if you have to work on a holiday. Okay, none of that is required by the labor code. But it's just like we were talking about at the beginning, the employer is required to adhere to the promises that the employer makes. Okay, so if the employer promises you that you're going to get paid holidays, then the employer is required to pay those holidays, and the courts will force them to pay the holidays if they try to change their mind. Okay, vacation pay is a pretty common perk in a lot of jobs. And if the employer promises you that you're getting vacation pay and you agree to go work with them, then they have to pay you for your vacation pay. then the same is true for working on holidays, okay? So none of these is automatic, but if the employer promises them, then they have to pay. The sick time is, they have no choice. They have to give you the sick time, and if they don't, then they're breaking the law. Okay, does that make sense? Next slide, please. All right, so another right that you have in the workplace is the right to take meal and rest breaks. Meal and rest breaks are required by law. It's not an employee, it's not up to an employer. The employer has to give you at least a 10-minute rest break for every 4 hours of work. Okay, so that means that if you work a 4-hour shift, or even a 3-hour, 45-minute shift, or a 5-hour shift, or a 6-hour shift, they have to give you one 10-minute rest break, okay? And that's a paid rest break. So you don't clock out. They just have to free you of all duty, allow you to do whatever you want for at least 10 minutes in the middle of that shift. And if they don't do that, then there are some legal ramifications. The other thing they're required to do, every time you work a block of 5 hours, they have to give you a 30-minute uninterrupted meal break. Okay, so the meal break means that you clock out, and then they have to give you at least 30 minutes to do whatever you want. You're not on call. There's no special duties. They can't force you to remain on the premises. You know, it's your time. And if they don't allow you to take that meal break, then that's also a legal violation. And note that both of these rules are based on blocks of work, okay? So if you get a paid rest break for every 4 hours. So if you have an 8-hour shift, you're gonna get 2 paid rest breaks. If you have a 12-hour shift, you're gonna get 3. The same is true of the meal breaks. If you have a 5-hour shift, you should get a 30-minute break. 6-hour shift, you should get a 30-minute break. 7-hour shift, you should get a 30-minute break. But when you get up to the 10-hour shift, they're required to give you 2 30-minute unpaid meal breaks. And if they don't do that, either one of these, that's a legal violation. There's a couple of exceptions that I noted here. One of them says that if you have a 6 hours or less in your workday, if both the employer and the employee agree, then you guys can agree to skip the meal break. It's also possible to do a special arrangement called an on-duty meal break. This is for the kind of employee who, for whatever reason, isn't able to leave the premises. There's no way to cover them. Sometimes this applies for, workers where there's only one worker on duty, and it doesn't make sense to, bring in somebody else to like run the shop for 30 minutes so the person can eat. And in that circumstance, the law allows the employee to enter a written agreement with the employer for an on-duty meal break. And then that person can agree that they get their 30 minutes, but they're on duty and they might be interrupted. And then the special privilege that they get is they get paid for their meal. So they have this 30 minutes during lunch where they still have to be paid because they're under the employer's control. All right. So let's talk about a few more things. Next slide, please. All right. So if the employer doesn't provide a rest or meal break, then they owe you some premiums. Premium is a legal term that they've made up for wages and for penalties. So what happens is the employer isn't required to come out and say, hey, go take your break. Okay, but the employer is required to allow you to exercise your right to your break. So if your employer does anything to prevent you from taking your meal breaks or your rest breaks, then they owe you a premium, which is an extra hour of wages for every day that happened. Okay, so say for whatever reason the employer said, hey, today you don't get to take any rest breaks and you don't get to take any meal breaks, then by law they're required to pay you for an extra 2 hours for that day. Okay, most employers won't just come out and pay you the extra 2 hours. Most of the time you have to take legal action. But once the legal action is complete, the employer is going to have to pay you for an extra hour for any day that you didn't get one of your breaks. And they're going to have to pay you for an extra hour for any day that you didn't get one of your meal periods. Okay. And the law says there's what's called a statute of limitations on most of these unpaid wages. So this is just reminding us that you can claim up going back up to 3 years. Okay, so any day that you didn't get a break going back to 2020, you can claim unpaid meal period premium in the Labor Commission or in court, which we'll talk about in a few minutes. Okay, let's move on to the next slide. So the last wage and hour rule that we're going to discuss is final pay. Final pay means that when the employer pays your last paycheck at the end of your job, they have to follow some very special rules about paying you. Okay? If the employer fires you or lays you off, they have to write you your final check immediately. And the final check has to include every penny that they owe you from all the hours that you've worked, including the last day when you're there to get your check. And they have to pay out all of your vacation time, and any overtime that they owe you, any tips or commissions that they're holding on to for you. They have to pay all of that out on your last day. And if there's any amount that's not paid out on your last day, that's a legal violation. Okay, if you quit and you tell them at least 72 hours before that you're going to quit, then they still have to pay you on the last day. The only time they get a little extra time is if you quit without notice. If you just walk in and say, hey, I quit, then the employer gets 3 days to give you your final check. But in all three of those cases, they have to pay you very promptly, and they can't just say, okay, well, wait for the next payroll. Or they can't say, well, we'll mail it to you. They have to give it to you immediately, okay? And if they don't do that, then they violated the law. And as I mentioned, the final paycheck has to have any unused vacation time. So remember, we said that the employer doesn't have to give you vacation time, but if they promise to, then they must. So if they promised you vacation time and you have some that you didn't use, then they have to pay that out in your last paycheck at your final rate of pay, okay? They don't have to pay out unused sick time when your job ends because you're not sick. That's just what the law says. So the sick time is going to disappear, but the unused vacation time has to be paid out. All right, so let's go to the next slide. All right, so this is the waiting time penalty. So this is what the law uses to punish the employers for not paying out your last check on time. If you have to wait an extra day for your check, then they owe you a penalty of an additional day's pay. Okay, if you have to wait 2 days for your check, they have to pay you 2 days extra pay. If you have to wait 10 days for your check, then they have to pay 10 days extra pay. That's how the waiting time penalty works. So if you are earning on average $200 a day, then they're going to owe you $200 extra for every day that you have to wait for your check. And that continues for up to 30 days. Okay, so what that means is that if you file a claim in a court or in the labor commissioner, and you prove that the employer didn't pay you something that they should have paid you, then the law says they should have paid that to you on your last day. And so since more than 30 days have passed since your last day, you're going to get several thousand extra dollars added to your award because of this waiting time penalty, because the employer failed to pay out everything they owed you on your last day. All right, let's go to the next slide. All right, so now that we've talked about a bunch of these rules that requires the employer to pay you, let's talk about a couple of the main exceptions. I mean, as with everything in the law, there's some main exceptions, and there's like small exceptions, and then there's exceptions to the exceptions. So I'm obviously not going to go into everything, but I am happy to look at any particular case that you want to talk about if you contact legal aid afterwards, okay? And we can probably talk about some of them in the question period. But here are some of the most common exceptions to some of the overtime and meal rest breaks rules, okay? So which are they? Next slide. All right, so some of the exceptions: independent contractors, exempt employees, and people who have a collective bargaining agreement. So let's talk about each of these. Independent contractors are people who are not your employees, okay? Independent contractors are people that you hire to do a quick job for you or for your business, okay? So when, for example, if your sink is leaking and you call the plumber and the plumber comes over and starts working to fix your sink, okay? You don't have to pay that guy overtime. You don't have to give that guy meal and rest breaks because he's not your employee. He's an independent contractor. Okay, so there are a lot of categories of people who work in their own business and they're independent contractors. And how do you tell if it's an independent contractor? Well, the person who's hiring you, they can't control the details of the work. It's outside of their ordinary business, and the worker has to have an independent business. Okay, so the plumber has an independent plumbing business. You know, the plumbing is outside of your business needs. I mean, in your house or in your business where you've hired the plumber, and you're not controlling the details of how the plumber, fixes the pipes. Okay, so all of those things mean that the plumber is an independent contractor. And there are other categories of people who are independent contractors. So those people are outside. They're not covered by these rules. Okay. A common problem that we see is that the business will say, oh, this secretary isn't my employee. She's my independent contractor secretary. Or they'll say, well, this waiter is really an independent contractor. No, I mean, that's ridiculous. Okay. If you're a restaurant, your waiter doesn't have an independent business and the work he's doing is part of the employer's business. So that's an employee. Okay. The same is true of, I've seen the independent contractor secretaries. I've seen people claim that that their housekeeper is an independent contractor. I mean, it is, somebody who like lives in your house and cleans your house is not an independent contractor. Okay. But if you hire Molly Maid to come out once and clean your house, then that could be an independent contractor. So it's it can be a little complicated, and some employers try to take advantage of it and say that their employees are really independent contractors so that they can avoid some of these rules. But it's almost always a fraud. And once somebody takes legal action, the employer usually owes some money. So it's definitely worth looking at if you have an employer who's telling you, oh, you're an independent contractor, I don't have to pay you, because it's usually a fraud. But, sometimes it's true. Okay, so we also have exempt categories of employees. Okay. Okay. For example, unfortunately, lawyers are exempt employees. So because I'm a lawyer, I don't get to charge overtime for coming in to do this presentation on a Saturday. I just have to do it because it's part of my job, right? So that's the rule. When you have exempt employees, they're not covered by overtime. Okay. Exempt employees include like the executives of your business, the high-level managers who are supervising people, the high-level administrators like your HR people. Okay, your artistic or learned professionals, that's the official legal term for people like me, attorneys, accountants, doctors, or artists. These sorts of people are considered to be exempt if they meet a bunch of qualifications. Okay, I mean, it's not just, oh, you're an artist, you don't get overtime. You have to be an artist and you have to be making a certain amount. I mean, there are underlying rules, but in general, those kinds of people are not going to be covered by overtime. Okay, personal attendants is the term for like, helpers for old people and babies who like, feed them and take care of them. They do get overtime, but it's a different rate. So I've included them here on the list. Another example is outside salespeople. So, if there's somebody who goes from house to house trying to sell you a closet or something, they don't have overtime protection. And then there's another exception for highly compensated computer professionals. So, somebody noticed that the attorneys and the accountants don't get paid overtime, but the computer professionals do. And so they said, hey, the computer professionals are making more than a lot of other exempt categories. So they made a new exempt category for computer professionals. So if you have a computer professional making over 100,000, they're not going to get overtime. All right. And then the final example that we've got here is collective bargaining agreement. A collective bargaining agreement means that in some jobs, there is a union, and the union sometimes agrees to bargain collectively on behalf of all the workers, and then they can make an arrangement with management. So sometimes the union and management come up with some new thing that they want to do. For example, I have a friend who works for the airline, and her union and management have decided that instead of working 5 days a week, 8 hours a day, they're going to work 4 days a week, 10 hours a day. And as you remember from the beginning, when you work 10 hours a day, you're supposed to get paid overtime. But the union is allowed to make a deal like that. So the union made a deal that they don't get paid overtime, they work 10 hours a day, and that's okay because it's a union agreement. So these are a few examples that are out there. So if you guys can think of some examples that you've seen, maybe it fits into one of these categories, or maybe it doesn't, and the employer is just pretending it fits into one of these categories. I mean, it's it's the Wild West out there in terms of what the employers decide they want to do, and it's always worth taking a look, because it's very unusual for the employer to make a mistake and pay you extra, but it's very common for them to make a mistake and keep some extra money for themselves. So let's go to the next slide, talk about a few more things, and then let's pause for some questions. All right. That's coming up. Okay, so workers' rights to wages regardless of immigration status. This is just to remind people. I mean, you might know some workers who don't have immigration status, and so they think, maybe they don't have the same rights. That's not true. Everybody has the same rights. You can't exploit somebody and pay them less than minimum wage just because they don't have immigration status. So that's what that's reminding you of. Next slide, please. All right, so this is just saying you can protect your rights by keeping written records. This I bet you guys already know, but the fact is, when you go into court or you go into a labor commissioner office to complain about your unpaid wages, it's not like the employer is going to say, "Oh, you're right, I didn't pay you for that." What they'll say is, "That's ridiculous. She's just a mean problem employee, and so she made up these allegations just to destroy us." I mean, they always lie. Okay, so that's why it's important to keep written records, because if you have some written records, you can prove that you're the one who's telling the truth and the employer is lying. Okay, so if you're submitting timesheets, take a picture of them with your phone to show what's going on, so that if the employer changes it later or doesn't pay you properly, you have proof that you worked those hours, and that the employer is lying. Okay, if the employer promises you something, like if the employer says, "Hey, I've decided that we're going to start doing vacation," or something like that, a good idea, send them an email and say, "Okay, well, I'm going to take my vacation on such and such a date," because then you have written proof that there was a promise of vacation and that you were trying to exercise it. And then if something goes wrong, you've got proof. Okay, if there's some problems at work, write down what's happening. Contact your union if you have them. If you don't, contact legal aid, contact some workers' rights organization, and describe what's happening, and then we'll take a look at it and see what's happening. Keep the names and the phone numbers of witnesses in case you get into litigation in the future. Then you can call up some witnesses who might be able to tell you what happened. Because what the employer will do, the employer will say, "Oh, we would never violate the law," and then they bring in a whole bunch of people who still work there and they force them to lie, and it's a big mess. So if you have some witnesses of your own, that's very helpful. So I would write down the names and contact information for some of the workers who might be able to help you out. Okay, what's the next slide? I think it's more about protecting your rights. Yeah, so save copies of time cards and pay stubs and checks. If it's just getting direct deposited to your account, take some screenshots. Keep copies of your deposit statements, keep copies of your W-2s. You want to be able to show that what the employer was paying you, and you want your attorney or the labor commissioner to be able to show that what was being paid was less than what was owed. Okay. You're also, if you get an employee manual, that usually has information about, promises that the employer made, things like vacation pay and stuff. If you've got a union contract, obviously keep the union contract. If there's handouts about your rights, you want to hold on to those, because that's the way you can show that the employer promised you stuff, and then you can use the courts to enforce those promises. All right, next slide. All right, so here's some other information. It's kind of basic, but I do sometimes get people who call me and they say, I want to sue my employer to get my unpaid wages. And I say, oh, what's the name of the company? Oh, I don't know. What's the employer? I don't know his name. You have to know the name of the employer if you want to sue them. So, you should get some basic information about your company. You want to know the name of the company. You want to know the names of the supervisors and the owners. Why? Because sometimes you're allowed to take legal action directly against the supervisor and the owner, and they can't say, "Oh, it's the company, not me." But if the person is actively involved in breaking the law, that person can be personally liable, and you can get money out of their bank account to pay you for your unpaid wages. So you want to write down that information: addresses, phone numbers. If you have license numbers, if you're working in a garment factory, the labor commissioner wants you to keep some of the labels, because then they can go after the company that is making the garments if they're not doing it properly. If you are just working as a day laborer, it's very helpful to write down the license plate number of the car of the person who hired you, so that you can identify them later if they don't pay you at least minimum wage. All right, next slide, please. All right. And so this is talking about recovering your unpaid wages. So assuming that your rights were violated, you were paid less than you should have been, and you've decided to take action, your options are, option one is to write a letter to the employer saying, hey, could you pay me? Usually they don't, although occasionally they will. So that's one first step. You can write a demand letter. Next slide. All right. And you can also file a claim with the California Labor Commissioner, or you can file a claim in small claims court. Those are the two easiest things to do. The Labor Commissioner is an office of the state of California that takes wage claims from workers, and you file a claim with them and you say, this is the amount I think I should have been paid, this is what they paid me, and then the Labor Commissioner does an investigation. They'll set you up for a settlement conference. Eventually you have a hearing in front of a labor commissioner deputy, and then they can order the employer to pay you. And the advantage of doing it this way is that it's much easier to go into the labor commissioner than it is to go to court. The disadvantage is that right now they're really backed up, so it takes a couple of years to complete the process, unfortunately. The other option is small claims court. Small claims court is great because it's fast. When you take the employer to small claims court, the case will be resolved in a month or two, and then you'll have an order that the employer has to pay. The disadvantage is that, it takes a little more work by yourself, because you have to represent yourself, and the judge is not necessarily going to be as sympathetic as the labor commissioner. And you're also limited to $10,000. So the small claims court can be a good choice for small claims that are less than $10,000. But if it's a larger amount, you're going to want to go to the labor commissioner. And it's also possible, if you have a really large claim and you want to go to court and you have a bunch of other claims against the employer, you can just get an attorney and go to the regular court, not small claims court, and then you can file a larger lawsuit. But that's more of an undertaking, and but it is another remedy that's available. All right, next slide. All right, so we've come to the end of the wage and hour review, and so I think, if you'd like, let's pause and look at some of these questions that have come up. And then after that, we can talk about a bunch of other civil rights that you have at work, and discuss some of the other stuff you can do. Okay. So I thought I saw some questions in the chat. So why don't I scroll through these and see if there's some that I can answer. Okay, so let's see. The thing about the employer requiring you to stay on premises during lunch, I was fuzzy about. Thank you. Yeah, that's true. As I said, the employer is not allowed to make you stay on the premises. They have to relieve you of all duty and allow you to make your own choices during your meal period, which has to be at least 30 minutes. Although, as we discussed, it's possible for you to make an agreement to stay on premises and be on call, but the employer has to pay you. And so they probably would prefer to relieve you of all duty for 30 minutes so that they don't have to pay you. Okay, so let's see. The whole time I thought we get paid our unused sick pay. Yeah, no, that's not true. You do get paid your unused vacation pay. And then there's some employers who they say, well, we're not going to have vacation and sick time. We're just going to have PTO, paid time off, that can be used for both vacation and sick. That's fine. That's okay under the law as long as they give you at least the minimum sick hours that are required by law, which, as we said, was 30 hours a year they have to let you use, or 40 hours starting next year. But if it's called paid time off, then they do have to pay it out at the end because it's not limited to sick pay. So if you have PTO instead of sick time, then they do have to pay that out. Okay, so let's see. Does one calculate overtime and double time with a 4-10 work week, meaning 10 hours of work for 4 days of the week? Okay, and so the answer to that question, as I said, if it is a union contract and the union has negotiated with management and the union and management have agreed that you're going to do a 4-10 work week and without overtime, then that's okay. Okay. But if there is no union and the employer has just announced, hey, by the way, we're doing a 4-10 work week, and you're not an exempt employee like the lawyers and the computer professionals and the executive president, then you are subject to overtime requirements. Okay. So that just because the employer makes up some rule and says this is how we're going to do it, that doesn't mean they're following the law. Okay. As I mentioned at the beginning, the government doesn't send inspectors to sit there and like in the employer's meetings and decide what they're going to do or not. Okay. So the law says that in the absence of a collective bargaining agreement, anytime you're working more than 8 hours a day, they have to pay you overtime. So that means in your 4-10 work week, it sounds like, unless there's some other exception that I'm not seeing on these facts, it sounds like they're going to owe you overtime for 2 hours every one of those days that you're working. Okay, so that would be something that I would advise you to contact legal aid or contact the labor commissioner, and I would challenge that because it sounds to me like a violation. All right, what's the question? How about if you go to the labor commissioner after 1.5 years and then no one shows up? What would be your next step? Okay, so what's happening with the labor commissioner is that they're pretty slow. So it's not a surprise to me that it would take 1.5 years to go to the labor commissioner. If no one shows up, meaning if you don't go and the employer doesn't go, then the labor commissioner will just close the case. Okay, but if you go and the employer doesn't go, then the labor commissioner will listen to you and hear your evidence. And if the labor commissioner is convinced that the employer is responsible, then the labor commissioner will just issue an order that the employer has to pay. If the employer gave up the rights to show up, that's on them. And so you could get a legally enforceable judgment against the employer, even if the employer doesn't participate in the labor commissioner process. Okay, so if anybody else wants to interject a question about the wage and hour right now, we could do that quickly, or if not, we'll just go on to the civil rights at work. All right. So Not hearing anything. If you guys get, if you have some other questions, we can talk about them at the end, okay? So let's talk about some of these other concepts. Oh, I see a hand. Yeah, go ahead. I'm listening.
Hi, yes, thank you so much. This is so informative. If you work 7 days and one of those days was a holiday like last Monday
Yeah.
and from Monday and then you're working today and tomorrow, does
Uh-huh.
that also count because there's a, a holiday within that 7 weeks?
Yeah. So you're asking about the overtime on the seventh day?
Yes.
Yeah. If there's a day that you don't work, then that's going to break up the 7 days. So they're not going to have to pay you overtime on the seventh day, even if the reason you're not working is because it's a holiday. Okay. But anytime that you are working 7 straight days, meaning you bill at least, a few minutes on 7 consecutive days, then on the seventh day, it's going to be overtime. And then, I mean, you might wonder, well, how do you get the 7 days? Does it start on Monday? Does it start on Sunday? Does it start on Saturday? I mean, the labor commissioner says, however the employer does the days, as long as they're consistent and they count it that way every week, then the labor commissioner will apply that. So most employers would start on maybe Sunday or Monday. But
Even
anytime,
though,
any
even
anytime you're
though
doing this, go for it. Go ahead.
even though one did not work on Monday, but they ended up working the other 6 days.
Yeah, if there's any day that you're not working any hours, then then the 7 day rule is not going to apply.
Okay,
But if you work anytime on that Monday, then yes, you're gonna have overtime on the seventh day.
thank you.
Yeah, like I said, usually employers that have professional payroll processors, cut your checks, they're gonna catch that and they're gonna pay you on the seventh day. But if they don't, I can almost guarantee the employer is gonna miss that. Oops, I didn't pay you properly. So you're gonna want to watch that if you're in the kind of a job where you're working 7 days straight. Okay, thank you for those questions. It does help me to elucidate these kinds of things. And it can be harder when you're on the computer, because it's not as comfortable to just raise your hand and say and give me your questions. So I appreciate everybody who's shared, because it makes it's easier for me to explain stuff if I have some examples. All right, so let's talk about some other civil rights at work. We've done a pretty in-depth view of some of these wage and hour stuff. These ones I'm just going to touch on so you have a sense of what is protected under the law and what isn't, because there's a lot of stuff that isn't protected. Okay, I get questions all the time like, oh, my supervisor is so mean. The law doesn't require the supervisor to be nice. I get questions, oh, my coworker isn't doing as much work as I am and I have to work a lot harder than her. Not illegal. Okay, the labor code doesn't tell the employers that they have to do a good job of running their business, but there are some minimum standards that are required by the labor code. Okay, so we're going to talk about some of those and try to give you a taste of the sorts of things that are protected. And again, you can ask follow-up questions now, or you can bring things that you're wondering about to legal aid or one of the other organizations, or you can just ask the Black Workers Center and they can contact us and get the answer for you. So that you can have a sense of which rights to be on the lookout for, and unfortunately, which rights you don't have a right to protection under the law, and you've just gotta suck it up. So let's talk about some of these rules. Okay, next slide. All right, so at will employment. Okay, this is the rule in California and most of the states. Okay, it means that unless you have a special contract that says that the employer can't fire you except under certain circumstances, then the employer is allowed to fire you for any reason at any time, anytime they want to. I mean, you can walk off the job anytime and quit. They can fire you anytime. That's what the law says in California. They can let you go for any reason. It can be a really good reason, like you did something terrible. It can be a really bad reason, like, they want to hire their friend and so they're firing you to make room for them. Okay. It can be a mistaken reason. It can be because the employer, mistakenly thought that you did something wrong, even though you didn't. It can be maybe another employee did something wrong and the employer mistakenly thought it was you, and so they fired you. I mean, that's not fair, but it's legal because the employer can fire you for any reason. Okay. And it can be no reason at all. I mean, the employer can, get a dice and like throw it and then say, okay, well, you're the one who's fired. I mean, there's no law that says that the employer has to be fair or just. And so as a result, a whole lot of the time, you'll get fired and you'll say, that's not fair. I didn't do anything wrong. Or, what I did wasn't worth getting fired for. And unfortunately, the law doesn't protect you or require the employer to make good or fair decisions in terms of who gets hired and fired. So that is something that you have to bear in mind because that's always the underlying rule. However, there are some exceptions. The exceptions include the anti-discrimination laws that we'll talk about in a moment. The exceptions include a breach of a contract. So if the employer has promised in a contract not to fire you unless they have a good reason, then the law requires them to have a good reason. Okay, same with a collective bargaining agreement. Union contracts almost always have termination provisions. They almost always require the employer to go through progressive discipline before they terminate you. And so if the employer has a contract like that and they break it, then that's illegal. And then there's breach of public policy grounded in statute or state constitution. What that means, that's a fancy legal way of saying that there's sometimes that the government just doesn't want employers to be firing you for some particular reasons. And so you'll have some protection in certain circumstances. Okay, so we'll talk about a couple of those rules. One of the most common is it's called whistleblower protection. And so there are circumstances where you've been a whistleblower, you've complained about some illegal conduct in the workplace, and then the employer, doesn't like people who are trying to get the employer in trouble, so they fire you. That's against the law. And the reason is because it's a breach of public policy in the statutes. So we'll talk a little bit about some of these issues. And like I said, we're perfectly happy to look at a particular thing. And I'll give you the legal aid contact information at the end if you want to contact us directly, okay? So let's look at the next slide. All right, so the first exception is discrimination, okay? Discrimination is when the employer does something bad to you, and one of the motivating factors that is causing them to do something bad to you is because of your membership in a protected group, okay? It doesn't have to be the only reason that they act, but if it's a motivating factor and one of the things that's informing the way that they're acting against you, then that's against the law. Okay, there's lots of protected categories in California: race, color, religion, sex, sexual orientation, national origin, your age. If you're over 40, if they discriminate against you because you're younger than 20 or whatever, that's not illegal. But if you're over 40, it's illegal. Genetic information, marital status, disability, medical condition. There's a few others too. And the employer is not allowed to discriminate on any of these categories. And then at the bottom, it says disparate treatment, disparate impact. Disparate treatment means the employer is not allowed to say, I'm doing this to you, and the reason I'm doing it is because of one of these categories. And they're also not allowed to do something that has a disparate impact. So, I mean, if the employer adopts some rule and it ends up excluding a lot of people, then that is also illegal. Okay. So for example, if the employer says, I'm only going to hire people who are 6 feet tall or more, I mean, you might think, okay, well, different people are 6 feet tall, but there's a lot more men who are 6 feet tall than women. So that kind of a category would have a disparate impact upon women. So that could be illegal sex discrimination. And there are a number of different rules that you can come up with. And if you see that the employer is engaging in some kind of activity that it looks like is showing disparate treatment or showing disparate impact, then that's something that's worth looking at and potentially taking action. I mean, the most obvious ways of finding discrimination, because just like the wage and hour, but even more so, it's not like you can go to court and say the employer is discriminating, and then the employer will say, oh, yes, you're right, I'm discriminating. They'll always say, oh no, we would never discriminate. And so it can be harder to prove, but you do have some tools at your disposal, usually by looking at giving examples of things that have happened in the workplace. I mean, sometimes the employer will make nasty comments, or sometimes the employers are really stupid. Like I had an employer recently who said, well, you know, you're getting old, so we're gonna have to like lay you off and get somebody else. So I'm like, okay, well, they've just admitted they're engaging in age discrimination, but that's unusual. Usually what you have to do is you have to say, look, you know, 3 people got fired recently. They were all members of this category. And, you know, 3 other people, you know, did really bad stuff recently, but they didn't get fired. And I mean, that's generally how you would prove disparate treatment in the workplace. You would say, hey, you know, based on these optics, it looks like the employer may have had a discriminatory motive when they fired me or demoted me or didn't promote me. Okay. And then the employer will always say, oh, no, that's not true. The reason we fired her or didn't promote her or demoted her is because X. Okay. And then the court or the EEOC or the California Civil Rights Department is going to look at that. They're going to look at the employer's explanation and they're going to say, does the employer's explanation make sense, or is it a pretext? And if they decide that the employer's explanation is a pretext because it doesn't make sense under the circumstances, then they're going to say, okay, well, then this probably could have been illegal discrimination as a motivating factor. And that's how they find out liability. Okay, so let's go on to the, well, let me add a few more comments. If you suspect that there has been discrimination in your workplace that has impacted you, or you know, someone you know, or some category of people in your workplace or in somebody else's workplace, you can encourage them to file a discrimination charge either with the EEOC, which is the federal government's anti-discrimination office, or you can file the charge with the Civil Rights Department, which is the state of California anti-discrimination office. Both of those offices, I mean, officially their role is to do an investigation. What generally happens is they come into the office, or maybe they'll do it on a Zoom call, and then they'll put a professional mediator in there with you. And then the mediator will talk to both parties, get their side of the story. And most of the time they will work out a settlement whereby the employer will pay, you know, usually a fairly small amount of money in exchange for settling the case. And then that is the resolution. That's the most common resolution in these kinds of claims. So, I mean, it's not always you know, earth-shattering how these cases come out, but in practice, most cases are resolved. Most employees who complain do get some money. I think probably 75% of the claims are going to settle during the mediation process, and you know, given that your other option is to just walk away and forget about it, for a lot of people that can be a better way to solve the problem. And then, of course, also, I mean, also you can just file these claims in court. But in order to do that, you have to hire an attorney who's going to represent you, and you have to, you know, go through a whole bunch of processes, and it can be complicated. And so the easiest thing for most people to do is to file a charge with EEOC or Civil Rights Department. Okay. Let's see, what's the next question? Let's go on to the next slide, and then we'll talk about a few more issues. Okay, so yeah, this is just filling up on some of the things I already mentioned. So this is reminding you that the employer can, I mean, the thing you see the most common is, oh, I got fired. But also, if the employer doesn't hire you and illegal discrimination is a motivating factor, that's illegal. If the employer disciplines you but doesn't discipline somebody else, you know, if illegal discrimination is a motivating factor, that's illegal. If you can show that you're getting paid less than somebody else, and you can show that there's a suspicion that that might have something to do with illegal discrimination, that's illegal. Same with benefits. Same with accommodation. I mean, if the employer is doing specific accommodations for some people but not for you, and if illegal discrimination is a motivating factor, that's definitely an issue. Also, if the employer refuses to accommodate you for some kind of protected accommodation reason, that can be illegal. There are all sorts of ways that employers can break the law, and this is just a sampling. And we're happy to look at particular cases and give you some advice and direction in the future. All right, next slide. All right, so harassment. Harassment is a legal concept, okay? It was developed from the anti-discrimination laws, okay? And so when we talk about harassment in normal life, what we mean is somebody's annoying us and won't leave us alone and is bothering us and causing us annoyance. And it doesn't matter why they're harassing us, right? In the law, in employment law, harassment means something specific. It means that the employer is creating a hostile work environment, and it means that the reason they're doing it is because of one of the discrimination categories that we've just talked about, okay? So, I mean, a lot of people have a mean boss, okay? And if the boss is being mean to you for any reason, it's usually not illegal. But if the boss is being mean to you because of one of these categories that we've talked about, then that could be illegal harassment, okay? So in the context of employment law, the only kind of harassment that's illegal is when it's done for some illegal discriminatory reason, okay? And then one of the subcategories is sexual harassment, okay? So sexual harassment, I mean, technically it's sexual harassment if the boss is mean to you because they don't like men, or they're mean to you because they don't like women. That's technically harassment based on sex. But then there's also the concept of sexual harassment in the way that we understand it, which means that the employer is either coming after you in a sexual way, or they're allowing other employees in the workplace to subject you to sexual advances or an unpleasantly sexually charged environment. There's two legal terms that attach here. It's illegal to do a quid pro quo sexual harassment, which means that it's illegal to say, hey, if you go to bed with me, maybe I'll give you a promotion. That's against the law. It's also against the law to create a hostile work environment, which means severe or pervasive conduct in the workplace that's changing the terms of the environment and making it hostile, okay? So if the employer is bothering you in a severe or pervasive way, either for sexual reasons or because of your race or because of your religion or your sexual orientation, if that's the motivating factor of the employer, then that can be unlawful harassment. And those kinds of claims are also frequently brought to the EEOC or the Civil Rights Department or in court, and they generally result in some kind of a settlement. Okay, so that's what you have to be aware of. So, I mean, I do get a lot of calls from people, and they say, "Oh, the employer's being really mean to me." And then the first question I have to ask is, why do you think they're doing that? Okay, because if the reason they're doing it is because of some kind of illegal motivation, then that can be illegal harassment. But if they're just doing it because they're a mean person, then that's generally not going to be against the law, and it might just be time to move to a different job. Okay, let's look at the next slide. All right, so leaving the discrimination categories, now we're going to talk about leave requirements. I mean, as with all of these, there's tons and tons and tons of additional detail that I'm leaving out. I'm just gonna let you know that under California law, if the employer has more than 50 employees, they have to give you up to 12 weeks of family leave every year if you need it for a special emergency or a health problem, or if you're having a child, or if you're adopting a child, or if somebody in your immediate family is sick and needs you to care for them. If you've been working for the employer for over a year and you've worked at least 1,250 hours in the last year, and the employer has more than 50 employees, they have to let you take up to 12 weeks of unpaid leave. And then they have to put you back in the same job you had or an equivalent job as soon as you return from leave. And they're not allowed to fire you for taking the leave, and they're not allowed to deny you the leave. It's all required by law. So that's something to bear in mind. Okay. And then down at the bottom, it's also saying that there's an additional pregnancy disability leave, which is up to another 4 months. So depending on how long you're disabled by pregnancy. So there are a lot of circumstances in which the employer is required to let you take time off work, and they're required to hold on to your job and put you back, and they can't fire you. So that's the idea of leave. Again, I'm just barely scratching the surface, and we can talk about this some more if you have a particular circumstance that you want to find out more about. Let's turn to the next slide. Okay. This next concept is called reasonable accommodation. And there are several circumstances where the employer is required by law to make a change to your job in order to allow you to do your job. And those reasonable accommodations that are the most common under the law are religious accommodations, disability accommodations, pregnancy accommodations, and domestic violence accommodations. Okay. And so in all 4 of those circumstances, and a few others that I'm not talking about, the employer is you are allowed to go to the employer and say, hey, employer, I have a religious accommodation that I need, or I have a disability and I need this change in the job in order to let me do my job, or I'm disabled by pregnancy and I need some time off, or maybe I need to sit down for most of the day where I would normally stand, or I need to go on light duty for a few months. Or you can go to the employer and say, hey, I'm experiencing a domestic violence situation and I need time off so that I can go through the legal processes to protect myself and my family and deal with some of the ramifications of the domestic violence. Or it could be even simpler than that. I need a shift change so that the person who's stalking me is not going to know where I am, or a transfer, or we need to hire extra security. These are all sorts of reasonable accommodations that are required by law under certain circumstances. If the employee comes to the employer and says, hey, I need this reasonable accommodation, then the employer is required to go through a process where they consider what the employee is asking for, and they consider whether there's a way to provide the accommodation. And if it turns out that the accommodation can be provided without putting a huge burden on the employer, then the employer is required to provide the accommodation. Okay, so if it's something simple and the employer just says, I'd prefer not to do that, that's illegal. It's required by law. If it's something really, really, really onerous, then, maybe the employer doesn't have to do it. It depends on the circumstances. It depends on how rich the employer is, what kind of resources they have. If you want to change shifts, it might depend on how many other employees they have to cover you. There are a lot of moving parts in these cases, but what's important to understand is you have the right to ask for the accommodation. The employer has to consider it. And if it's not a tremendous burden, then the employer is required to grant it. All right, let's look at the next slide. Language rules. Okay, this just means there are some employers who want to have a rule that, you can only speak English. maybe because like the customers think that you're talking about them or something. And so they have to have a particular policy, and they're not allowed to tell you that you have to speak English during your breaks. Those are the important rules. All right, next slide. All right, retaliation. Okay, this is another circumstance in which the employer is maybe prohibited from doing something based on the circumstances. If you have engaged in what's called protected activity, okay, if you have complained about potential illegal conduct in the workplace, if you have participated in somebody's lawsuit against the workplace, if you have gone to the employer and said, hey, I'm not being paid in accordance with the law, or if you've said, hey, I think there's a safety violation here, or if you say, hey, this person is harassing me. I mean, any kind of protected activity, which is, usually defined as whistleblowing, complaining to your supervisor, complaining to the employer, complaining to the police, complaining to a government agency, anything like that is protected activity. And if the employer takes steps to punish you or retaliate against you for doing that, then that's against the law. Okay, so there's a lot of litigation about this when there's, potentially illegal retaliation. And usually the way you know it's retaliation is because the employer starts to take action or change their attitude towards you, shortly after you make the complaint. So that's something to bear in mind. You're protected with regard to those kinds of things, and it's important to remember that and to exercise your rights as appropriate. And you can file claims in the labor commissioner or in court, or in the if the retaliation is related to some kind of discrimination, then you can also file those with the EEOC or the Civil Rights Department. All right, next slide. All right, privacy issues. Okay, so this is just a quick rundown. You do have some privacy issues in the workplace. And there are some limits on what an employer can do to invade your privacy. There's so many different rules. You would probably have to, if you think the employer is invading your privacy in an illegal way, contact legal aid, and we'll take a look at the circumstances. What I can basically tell you, some of the examples. If you're using a work computer, the employer is allowed to, read your email for work, okay? But they're not allowed to force you to give them your phone and let them read your personal stuff, okay? There's limits on what the employer can do and what they can't do, and it depends on the circumstances, okay? They're allowed to, when you're applying for a job, they're allowed to ask you about your criminal convictions, but they're not allowed to ask you if you've ever been arrested unless there was a criminal conviction, okay? When you apply for a job, they're not allowed to talk about your criminal convictions, if any, until after they've already decided to give you an offer of employment. And then at that point, they're allowed to get a background check. And then if there are convictions that they're concerned about, then they have to engage in a dialogue with you and allow you to explain why that doesn't matter anymore. And they're not allowed, you're not required to disclose expunged convictions or things like that. So there's limits, in terms of what's reasonable and what's not reasonable. They're usually not allowed to look at your credit report. They are allowed to have you take a drug test when you're first applying. And if you're in some kind of a safety job, there are circumstances in which they're allowed to do more drug testing while you're working for them, but in most cases they're not. All of this is very, very specific to the particular question involved. But in general, just know that you do have limited privacy rights, even in the workplace, okay? Next slide. All right, severance pay. I do get questions about this. This should probably be in the wage and hour section. The answer for severance pay, does my employer owe me some money when I leave my job? The answer is no, the employer is not required to pay severance pay, but oftentimes they do. I mean, it depends on the circumstances. Sometimes you have a contract that says the employer is going to pay severance when you leave. Sometimes the employer just has a policy that they offer severance. More frequently, when you're leaving, the employer will offer you a severance agreement in exchange for a legal release. So a lot of people get offered a few extra weeks or months of pay at the time they're leaving, in exchange for waiving potential legal claims. And then there's also a rule when there's a mass layoff at a large plant closing or something. If the employer doesn't give you enough notice, then they might have to pay you severance pay. But in general, it's something you can agree to do with the employer, but it's not required by law. All right, let's see the next slide. I think we're getting close to the end. Yeah, unemployment benefits. So like I said, this is a big part of what legal aid does. We help people access their unemployment because when you apply for unemployment, you submit an application online and then it goes to an EDD worker, and the EDD workers are not the smartest. I mean, some of them are just recently hired. They don't know the rules. They make stuff up. And so a lot of people get inappropriately denied. And then you just receive a letter that's like, oh, you're not eligible. And then, how do you know if the EDD worker is right or wrong? And the answer is that frequently you need to appeal. So that's a lot of what my job is. But in terms of the underlying rules, anytime you're losing your job through no fault of your own, you're usually going to be able to get about 6 months of unemployment benefits, up until you start a new job. Okay. So employees are entitled to unemployment insurance. Independent contractors, remember, those are people like the plumber or whatever, they're not going to be entitled to unemployment insurance because you have to be an employee and the employer has to be paying taxes on your wages for employees. But there are misclassified employees there, which means that the employer may have, illegally pretended you were an independent contractor, and even though you're an employee, those people can still get unemployment benefits. They just have to tell the EDD that they've been misclassified, and then EDD will investigate, send the employer a bill, and send you some unemployment. Okay, so workers who are laid off are generally going to be eligible for unemployment because obviously it's not your fault you were laid off. People who voluntarily quit their job are sometimes eligible for unemployment. But again, the underlying question is it no fault of your own? Okay. So if you just decide willy-nilly that you would rather not work there anymore, that's probably not going to get you unemployment. Okay. But remember, we were talking a few minutes ago about the circumstances where the employer's being really nasty to you, or, otherwise the job is not working out. We were talking about circumstances where you might be sick or somebody might be sick and you might need to take time off. I mean, there are circumstances where you have a very good cause that you need to quit your job. And if you can show that you had a very compelling reason that would have made a normal person quit under those circumstances, and you can show that you tried to work with the employer first to see if you could fix the problem before quitting, under those circumstances, you will get unemployment. But it has to be a very good reason, and you have to have tried to work it out first. If you can satisfy those two things, then you can get unemployment even if you quit. The last concept is you can be terminated, but it has to be for reasons other than misconduct. Okay, misconduct means you did something really bad at work and they fired you for it. Okay, if you did something really bad at work and they fired you for it, then you're not eligible for unemployment. But if you did something minor, or it's just not working out, or they wanted to hire somebody else, or you were trying your best, but they're just not satisfied. I mean, anything except like a major breach, you would be eligible for unemployment. Okay, so it just depends on the circumstances. But I mean, you get a lot of appeals that are based on this. Then the question is, I mean, maybe you like missed a meeting or something, but did you do that on purpose? Were you trying to harm the employer, or did you just like oversleep? Okay, I mean, that's the question. If it's something that's really, not your fault or not that bad, then you're still going to get unemployment. All right. That's the end of this slide. I don't know, is there one more? Let's check. Yes. Okay. Yeah. This is just a reminder that for all of these concepts, it's important to keep track of what is going on at work that you think might be illegal, and documentation of the discriminatory conduct. Lots of employers are sending you emails, lots of employers are sending you text messages. You want to keep those because you're going to need evidence if you end up in any kind of litigation over any of these issues. Because as I said, the employer will always say that you're making it up and that you're just a crazy, angry person who has a vendetta against them. And so you're just trying to get them in trouble. So you want to have evidence to back up your story. And it's even true for unemployment, because a lot of the time, you'll be applying for unemployment and the employer will say, oh, she did something terrible. And then if you have evidence, if you have some emails that you can show the unemployment judge, it makes it easier to win your case if you have evidence. Okay. And then down at the bottom, I mean, those are some phone numbers for the labor commissioner and the Department of Fair Employment and Housing, which is now called the Civil Rights Department. And yeah, I mean, contact legal aid if you have issues, and we can direct you to the proper agency and teach you about how to go about defending your rights. All right, so what's the next slide? I think it's probably my phone number. Yeah. Okay. So you're also allowed and encouraged to contact legal aid with any kinds of questions about circumstances. We're happy to take a look at your case, advise you, tell you what we think is illegal, what isn't, and tell you which agency we think you should go to, or if we think you should go to court. We can help connect you to private attorneys who might want to do a lawsuit for you on contingency, or we can teach you how to get through the agencies and try to get a good settlement. We can sometimes represent you in labor commissioner actions. We can represent you in unemployment appeals if we think your unemployment has been improperly denied. And so that's what we're here for. We've got 2 attorneys and 1 paralegal. So we certainly do at the very least, we'll give you some advice. And even if our answer is, what you're complaining about is not illegal, that's good to know, right? It's there are no stupid questions. It's always a good idea to get a sense of what's going on. Legal aid is only allowed to assist low-income workers. So if you're kind of rich, then what we'll do is we'll connect you to one of the other legal aids that doesn't have the income restrictions. But yeah, we're more than happy to help you out. And you can call that number. We also have a website. It's just lafla.org. And you can submit an application on lafla.org. And if we have some time, let's look at some of these questions that popped up while we were talking about the other issues. And let me see if I can give you some guidance. Okay, so let's see. All right, so how about if you go, okay, that we read that. Okay, so holidays are double time or time and a half. Okay, holidays are double time and time and a half. If the employer agrees to pay you for holidays, then the amount that they pay you for holidays depends on your agreement with the employer. There's nothing in the labor code that requires them to pay you extra on holidays. But a lot of employers do. They say, hey, if you're going to work Christmas, then we'll pay you time and a half. We'll pay you double time. I mean, my friend, the airline worker that I talked about, they get paid there 3 times on holidays. So I never see her on holidays because she always goes to work. But yeah, it's 100% up to the agreement you make with the employer. There's nothing required. All right. So what's the next question? What if an employer continues to not give me a break but pays a penalty? That's legal. I mean, if the employer is, the law doesn't say it's illegal to not give breaks. The law says that the employer either needs to authorize the break or they need to pay you premium pay. So most employers will either give you the break or they'll try to cheat you out of it and not pay the premium pay. But if the employer is paying the premium pay, that's not illegal. There are some employers, and I've seen it because the workers bring me their paychecks where it's like premium pay and they get extra pay on the days that they miss their break. or that their break was too late, or that it was not long enough, or that there was some other non-complying part. So that's not illegal. Okay. So also, can you talk a bit more about work week and how employers use it to avoid overtime? Okay. Yeah, I mean, there are some schemes that employers come up with to avoid paying overtime. I mean, I've seen you mentioned the security officer industry. I mean, I saw a security officer recently, and his employer had told him, well, we're going to pay you $120 a day. And it didn't matter that he was working all these overtime hours, or that they were sending him to 2 sites and he was working 12, 13, 14, 16-hour days. Okay. Definitely the employers will try to come up with some scheme, even if it's as simple as just saying, well, I'm going to pay you a particular amount per day. I mean, remember, unless you're a salaried exempt employee, you shouldn't be paid by the day. I mean, you should be paid by the hour, and the total amount you're paid has to include all of at least the minimum wage plus overtime. And if you're getting paid less than minimum wage plus overtime, or if you're getting paid the same amount if you work 7 hours, 10 hours, 13 hours, that's definitely going to be a violation. And so it's important to look out for that, and ask questions or file a claim if you think the employer is cheating you. Next question: can you still get paid if you have a day off? It depends on the circumstances. Some employers do have paid time off. Some employers do have vacation time. I mean, if you have those, then you'll still get paid for a day off. If you are an exempt salaried employee, meaning if you're making more than like $60,000 or $70,000 a year, you're paid on salary and you fit into one of the exemptions, then sure. I mean, by law, they still have to pay you if you take the day off. If they cut your pay because you worked less, then you lose the exemption, and then they have to pay overtime. So there are circumstances. Obviously, if you're sick and you have to take a day off using your sick time, then you're still going to get paid. But if you're just an hourly employee and none of those circumstances applies, if you don't work, they don't have to pay you for a particular day. All right. Next question is about connections to legal aid. So yeah, you saw the phone number, and then our website is lafla.org, and you can apply on there. Let's see. Would you believe that one of my coworkers was clocked in and off work, got paid for it? Management came in to tell her the money needs to come back, and she said, no, not my fault. She did not return the money and not fired. I have seen every single one of those circumstances at some point throughout my career. It's definitely there are a lot of issues there. I mean, obviously, I'm usually more concerned about employers who are defrauding the employees, but there are some employees who try to defraud the employer by time clock manipulation. So that's something that the employer could sue you about. She said, no, not my fault. Yeah, the employer is generally not going to be able to just like claw the money back by stealing out of your next paycheck. They would have to, if they overpaid you for some reason, they're going to have to file a lawsuit against you if they want to get the money back. And then she didn't return the money and not fired. Yeah, sometimes employers decide if it's like a special favoritism employee that they're not going to fire them, even though they did something bad. Generally that's not illegal. Like I said, the labor code doesn't require the employers to be fair or just or, not play favorites. I mean, the employer generally has the right to make their own employment decisions unless they're violating one of these rules. So if they decided to let some lady who stole from them keep working for them, I mean, we can question whether that's a good idea, but it's the law doesn't require it one way or the other. The next question is, to file for discrimination federally, there must be 15 plus employees, and to be able to file discrimination in California, there must be 5 plus employees. It depends on the circumstances and the kind of discrimination involved. But you're right. In general, under federal law, it's going to be a place with more employees. And in general, in California, I mean, there's different kinds of discrimination that require fewer employees. So I mean, even if it's just you as an employee, the employer, the sexual harassment is still against the law, even if it's not 5+ employees. Okay. But some of the other discrimination rules do require 5+ employees. I mean, it depends on the circumstances, because there's literally a different statutory line for each one of these things, and some of them are more employees, some of them are less. It's just a question of when these laws were written. You of course had advocates who were fighting for workers' rights, and then of course you had businesses saying, no, this is going to hurt the business, and so they come up with a compromise, and so there's different numbers of employees that are necessary. But it's some of the rules apply even to one employee, and some of them have a few more. It just depends. Okay. Let's see. Discrimination is very hard to prove. Yeah, double underline. That is true. It is very hard to prove discrimination. And in general, like I said, you can only prove it inferentially. Okay, nobody's going to go in and say, yes, I discriminated. They're all going to say, no, of course I would never do that, I love everyone. And so you really have to show, hey, here's an example of somebody who did something bad and you did nothing to them, and then here's an example of somebody who has these protected characteristics and you did something to them, and what's the reason? And then the court's going to look at it and decide what they think is the reason they did it. So if you get a lawyer and you file a lawsuit, then a jury's going to have to make that decision. Okay. But if you go to EEOC or you go to Civil Rights Department and you're sitting in the mediator, I mean, what's going to happen in the end is the employer is going to say, of course I would never discriminate, but I'll write you a check to resolve the situation. So that's usually what ends up happening. Nobody's gonna admit that they did anything wrong. But if the circumstances look fishy, then yeah, you're probably going to get either a small settlement payment, or you're going to go to court and fight it out and see what the jury awards. Okay, but yeah, you're definitely right. It's definitely hard to prove. Okay, and it definitely helps to have notes, text messages, emails. I mean, you do the best you can with what's available, but it's very hard to read what's going on inside somebody's brain when they're acting. And so, we have imperfect legal tools to try to enforce these laws. Okay, so next question. Under retaliation, can your supervisor reduce your 40-hour work week by 5 hours? Would this be considered retaliation? Yeah, the answer is it's retaliation if the reason they're doing it is because of your protected conduct. Okay, so if you complained about illegal conduct and then they reduce your hours, then yeah, a court is probably going to say that sounds like retaliation because look at the timing. Okay, but if they cut your hours and they also cut everybody else's hours, and you say, well, 3 years ago I complained and I think this is retaliation, the employer is going to say, no, I was cutting everybody else's hours because we have less work. I mean, if they can convince a judge or a mediator or a jury that it wasn't illegal retaliation and that they had some other reason, then you're going to lose. But if you can show that the reason they cut your hours was because of some illegal retaliation against some protected conduct that you had, then you could win. All right. With unemployment, what if the employer lies and says they terminated you because of policy violation and performance issues? Does that make it hard for the person to get unemployment? Okay, so number one, as I've tried to emphasize, the employers lie all the time. Okay, that's not unusual. Okay, if they said something vague like policy violation and performance issues, that probably wouldn't block you from getting unemployment, but it might make it harder. Yeah, because once you apply for unemployment, EDD is going to say, what's the reason why you were terminated? And then you say, well, here's what the employer said. And then they call the employer and then they say, employer, what's the reason you terminated them? And then the employer says, they did this and that. And then the EDD worker has to decide, okay, is what they're alleging so terrible that it's going to count as misconduct? Or is it, some minor violation or inefficiency or, a one-time judgment error that's not misconduct? Okay. And so if it's a one-time minor policy violation and performance issues, then that doesn't sound like it's rising to the level of misconduct, but it would depend on the circumstances. And I could totally see EDD denying, and then you might have to appeal, and then you might have to show a judge that in fact, you were trying your best, or whatever the policy violation was just an honest mistake or something, and then you probably would get benefits in the end. But it definitely will slow down the application process. And frequently what happens is if you have to go through the whole appeal, unfortunately, it's going to take a few months to get you on unemployment, and you're probably going to be back working by the time you get paid your unemployment, and then they're just going to cut you a check for the months that you missed. So it's not a perfect system. Let's put it that way. All right, what's the next question? What if you were fired and you had a non-compete contract? Can you still work for the competitor? The answer is almost certainly yes, you can. Non-compete contracts are very, 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 very disfavored under California law. There's only a few tiny exceptions. The law generally provides that nobody is to be restrained from working freely in California. So I am pretty sure, I mean, it would depend on the circumstances. There might be some tiny exception. I mean, an exception is like an attorney who's leaving a law partnership, can't take some of the clients. But I mean, most of the time, yes, you are allowed. So even if you sign something saying, I'll never work in another restaurant so that I'm not competing, yeah, I mean, whatever. I mean, you can. And if the employer tries to go to court to stop you from doing your job, they're going to be kicked out of court because it's not enforceable. Okay. What's the next question? Is there a cost for the help? Yeah, Legal Aid Foundation, as I mentioned, the reason why we can only help low-income workers is because legal aid gets all of our expenses are paid by the federal government. So the Legal Aid Legal Services Corporation is part of the federal government. They pay for us to operate. They pay my salary. So all of our services are free. Okay. Next question. What are the days we can call? I don't know, Monday through Friday. Or go on the website. You can do that 24 hours a day. Will the slides be available post meeting? Sure. I mean, you could ask the organizers to send you a copy of the PDF that we're looking at right now. I'm more than happy to share it. Do whatever you want with it. It's for you. That's why we made it. All right. What if the employer forces you to sign meal break waivers? Can they do that? The answer is no. A meal break waiver has to be voluntary. If you go to the labor commissioner or court and you say that you were forced to sign this waiver, then the employer is not going to be able to use it. It has to be voluntary. All right, next question. They wanted her to work off the clock. She said no. All right, well, good. I mean, if you're not working off the clock is illegal, obviously. I mean, I think everybody knows that because of the concept that we talked about earlier, which is that even if the person agrees to work for less than minimum wage, it's against the law. And the person can agree to work off the clock and then turn right around and file a lawsuit for the unpaid wages. And then the employer, sometimes they do. They'll say, but she wanted to work the extra time. Who cares? I mean, you've got to be paid at least minimum wage plus overtime. You can't waive it. All right, next question. Can you file for overtime and double time for working camping trips? Well, yeah, sure. I mean, camping trips, if there's an employer and they're allowing you to work the camping trip, then they're going to have to pay you for it. I mean, I could see maybe if it's like a church, maybe there's some kind of a religious exception. But in general, if you're running a camping trip and providing services, then they're going to have to pay you overtime for the time that you're under their control. I mean, for the time that you're asleep or the time that you're free to do whatever you want, they don't have to pay you. But the time that you're actually providing services and the employer is allowing you to work, then they have to pay you. All right. Can I go back and sue some employers now that I'm informed? You can if it's within the statute of limitations. Most of the laws we've been talking about have a 3-year statute of limitations. So that means that the violations that you're complaining about or the wages that should have been paid would have needed to be paid within it's October 2023. So things that happened since October 2020, you can still complain about. Stuff that was earlier than that is probably outside. All right, new union reps who seem to be in the pocket of the company instead of you. Well, that's an issue because you need if you're going to enforce your union rights, then you have to go through the union process, and that requires the union representatives. So if there's some problem with that, you might have to contact the higher level higher level union that is above the union that you have, because they're usually part of a larger national union, or you could contact the National Labor Relations Board. What if the employer cuts your hours because the employee wanted to discuss fair pay before taking on additional responsibilities? Would this be considered retaliation? Depends. I mean, if your discussion of fair pay means that you're complaining about conduct in the workplace that you see as illegal, then yes, that could be retaliation. But if my discussion of fair pay is I go to my boss and I say, I'd like a raise, and then she doesn't want to give me a raise, she's allowed to retaliate. I don't have a legal right I don't have a protected legal right to ask for a raise. I do have a protected legal right to complain about illegal conduct in the workplace. Okay. All right. So I think I made it through all of the questions. If anybody has some final thought, I'm happy to take it. But otherwise, I really appreciate everybody's attention, and it's always a pleasure to be able to talk about these rights, because they're not obvious. Some employers don't know them. A lot of employers do know them, and they try to cheat you. Employers will make up their own rules, and if nobody sues them, then they say, oh, well, I guess I know the rules, but they break the rules all the time. I see it. It happens at legal aid. Sometimes I have to call our HR and say, what the heck are you doing? You're breaking the employment law. And are they like, thank you, Matt, for giving us the law? Are they like, how dare you? I mean, but I tell them, obviously they can't retaliate against me for complaining about illegal conduct. I'm just trying to help them. Right. So yeah, you've got to be proactive with this kind of stuff, because nobody's looking out for your rights except you. So if you've got questions, if you've got circumstances, call legal aid, contact somebody, tell them to contact legal aid. We'll help you, and we'll get you connected to the right resources, and we will help you analyze your legal rights. Okay. So it's been a pleasure.
Thank you so much, Matthew. We really appreciate it. It was a powerful presentation. And I also feel the need to say that if you are a union member, you should go to your union representative before you decide to file claims with any of the organizations that he mentioned. Also, if you want to join the Stewards Council and be a part of these informative and impactful trainings, please drop your email in the chat. And I appreciate all of y'all for showing up today on Saturday. Thank you so much. And that's it today. If you have any more questions, I think you guys have stuff in the chat. Everybody's saying thank you. Thank you so much. Bye. Oh, wait, I gotta make